The most important thing to know in a DWI is that you have 15 days from the date of your arrest to request an ALR hearing, which is our chance to protect your license, win that hearing, and keep your license from ever being suspended. The first thing someone thinks whenever they're arrested for a DWI in Texas is, how do I get out of this? A lot of times people think, oh, I wasn't drunk. I'm not guilty of this. They don't have a case against me, and they think they can just let it go. But that's not how you handle a DWI in Texas. There's a lot of collateral consequences when you are arrested for a DWI. The collateral consequences of a DWI vary anywhere from your driver's license being suspended or your job being put at stake if you have to drive a commercial vehicle, or if you work for a company and drive a company vehicle. Your insurance can also go up if you are convicted of DWI. A DWI third in Texas is a third-degree felony. It carries a range of punishment of 2 to 10 years in TDC, prison, and up to a $10,000 fine. It's extremely important for someone who's been accused of multiple DWIs, and even if you're at a DWI second, especially whenever you're at DWI third or more, you have to have an attorney who knows the ins and outs of DWIs, what goes along with them, the technicalities, because there's a lot at stake. When you're at a DWI third, you are looking at prison time. And if the attorney does not understand the ins and outs and the technicalities of a DWI, they cannot adequately represent you and fight that case. The key to winning a DWI is knowing what to look for, knowing how an officer is supposed to administer the standardized field sobriety test, or SFSTs. All officers, they are all trained by NHTSA protocols. If they are not properly done, then they should not be considered in determining whether or not there was probable cause to arrest someone for DWI. And if there's not probable cause, then the case should not proceed and it should be dismissed. If probable cause did not exist for the stop, then they should have never even done the tests. And whenever that happens, suppression issues come into play. If there wasn't sufficient probable cause to stop the person, then you attack that case from the stop. In order to find these technicalities, I get the manual. I have the manual that the officers are trained by. I use it when I am evaluating the videos in a DWI case. And if they don't administer each of the 3 tests properly, that's how you get them on their technicalities.
I was the former head of the vehicular crime section for the district attorney's office in Harris County. That put me at the forefront in the state of handling DWI and intoxication manslaughter cases. And in that experience, I learned how police officers investigate those cases, how prosecutors prosecute those cases. I was able to take that experience and use that to my advantage in defending people in these cases. I've represented thousands of individuals, have obtained hundreds of dismissals, numerous acquittals, and I'm constantly called on by local and state associations to speak to lawyers about how to defend a DWI case, how to beat a DWI case. I've spoken frequently on how to pick a jury, how to beat blood tests, how to beat breath tests, and so I use all that knowledge and experience to benefit our clients in these types of cases.
The biggest mistake anyone can make in their defense is just sitting back and thinking things are going to go away. People go to court and they think, I didn't do this, it's just a DWI, it's no big deal, I'm just going to handle it myself, save a few bucks. And that's the worst mistake you can make. A DWI is extremely technical, and you have to have someone with the experience and know-how to handle a DWI.